Hello and welcome to the Magna Carta Prelims 2024. This is lecture number 10 on federalism. Now, before we begin, let's just generally have a context with respect to how questions from federalism are generally asked in the prelims exam. Now, it is generally seen once we've analyzed papers that have been there in the last 10 years or so, the questions from federalism have been very minimal and they have been mostly application based. If you simply understand golden rule number 2, which is center stronger than the states, wherein the center will exercise some form of superiority, there will be some form of appeasement that is given to the states, and eventually that appeasement is going to be a hollow sense of appeasement. You should be able to answer most of the questions that come from here. But having said that, federalism from a more analytical angle, from a more uh, technical angle, is largely a domain for the mains exam. So when we study federalism for the prelims exam, we've got to basically understand its conceptual framework, like we did for separation of powers. We must also understand its forms of existence, and we must understand its applications, wherein we are able to see some form of reflection of the center stronger than the states. Because ultimately, it's about the relationship between the center and the state government. So let's begin with the concept of federalism. See, in one line, federalism could be understood in the Indian context as a constitutional allocation of distribution of powers. This constitutional allocation of distribution of powers would effectively happen between two or more levels of government. In India, we have kept this distribution of powers between two layers of government, which is the central government and the state government. Post the 1990s, where we've also constitutionalized local self-government, it becomes a very unique case of federal application, because though the local self-governments are constitutionally mandated, the powers and the functions and the sources of finances of these local self-governments are largely left to the affairs of the states. So what you can basically ensure is that every state has a sarpanch. But what is it that the sarpanch has the powers to do would effectively be left to the state government, which is why federalism is largely an understanding of the relationship between the center and the states. And therefore, governments at both the national and the state level function in their respective jurisdictions with considerable amount of independence from one another. Now, of course, if you look at some of the major federal polities in the world, you would count the US, Canada, Switzerland, Australia, India, and so on and so forth. And theoretically, one has generally seen two models of federalism. One has been the coming together model, and the other has been the holding together model. Now, what is the basic difference between the two? The coming together model is simple when you have few units which come together, few provincial units which voluntarily want to form a strong union. A classic example of the coming together model would therefore be the United States. But you also have a model called the holding together model. In the holding together model, you will generally see geographically vast and culturally very diverse provincial units, which have to be given autonomy, which have to be given some form of administrative ambit, and they are essentially a part of a larger union, which is effectively the best case of India, because India is a clear-cut representative of the holding together model, because you're holding India together. despite the fact that India is geographically very, very vast, because of the fact that India has great cultural diversity. In fact, the difference between the northern and the southern states of India, in terms of language, in terms of culture, in terms of economic propensities, in terms of social structures, could very easily be the difference between two European countries. So, commonality is not a reason why India is a country. Because of certain larger common ideals, common aspirations, some resources that could be commonly shared, the fact that you want to create a strong nationalized polity is why you have a holding together model. And in fact, the holding together model is quite contradictory and quite paradoxical to the larger idea of what is called centralized federalism. Because on the one hand, you want to create centers stronger than the states, but you also have to maintain the individuality of the states. And generally, it is seen that in culturally diverse countries, in developing countries like India, federalism is not just chosen for administrative requirements, it is also chosen for the very survival of the country. You will have to keep your constituent units happy and at the same time give them enough of a sustenance, because a lot of times if you look at some of the states in the country which are not doing very well, which are not very well endowed when it comes to resources, when it comes down to literacy, when it comes down to industry, if it weren't for the fact that these states were a part of the country called India, it would have been very difficult for these states to have survived as independent autonomous regions in the world. And for exactly these reasons, the framers of the Indian Constitution were very, very skeptical. And in fact, they refrained from creating a fully federal political system. See, the word federal means the sheer existence of a center and a state government. Federalism does not mean center stronger than the states. Our nature of federalism is center stronger than the states. So any country in the world which has two layers of government at the bare minimum is a federal country. So therefore, when we talk about fully federalized or when we talk about a pure federalism, you would want to give some substantial powers to the states, which of course has not happened in India because of the reasons that we've discussed. And that is also why the framers of the constitution were not very much in favor of creating a fully federalized um, country as a whole, because you would have very clear cut tendencies of leaving the country, very clear cut tendencies of disunity. And the fact that the partition was a great point of context for us, we could not afford any further bifurcation or any further disintegration, which is why a political philosopher and a great thinker of his time, Casey Ware, actually categorized India's federalism in the nature of what is called that India is a quasi-federal country. And our nature of federalism has also evolved over a period of time. You would see that from 1947 to 1967, from maybe 1968 to about 1989, from maybe 1990 till about 2014, and post 2014 onwards, one could certainly say that there is a distinct change in the way federalism has been understood. In the first phase, you would see language and linguistic basis as a very clear-cut instrument of federalism. This would lead to the second phase, where you'll see the growth of regionalism in the country. You will see the growth of regional parties. You will see very, very strong regional forces coming to shape and power in the country. The third phase, when you see radical economic reforms, financial autonomy, You'll see a very extensive use of Article 356. You'll see a lot of these factors, including the fact that the party at that time was slowly losing its national clout. It also has an impact. The fact that you are strengthening local self-government will also have an impact, and that's generally the third phase. And today, you see a very nuanced form of federalism. You see things like the GST Council, you'll see Niti Aayog, you'll see a concept called national federalism being the absolute reality of India today. And therefore, there is as much an assertion of regional parties, there is also an equally good stronghold, if not more, as the case might be, of national parties. And especially when we see catastrophic events like the pandemic, one cannot ignore the crucial role of the state in and state governments in helping the country, fight the pandemic. So the nature of federalism has also effectively changed. But as far as the prelims is concerned, we have to have a very objective understanding of federalism. We have to have a very black and white understanding of federalism. So let's first begin by understanding the very essentials of federalism. Now, on the left side, what you can see are certain characteristics or certain types of federalism. On the right side, what you see are things that make federalism possible. So let's first understand the left side. When we are referring to, say, the types or the characteristics of federalism, we begin with the term that we've already discussed in a very small amount of detail called quasi-federalism. Now, quasi in itself means semi. So when we say that we are a quasi-federal country, what we effectively mean is that we're a country where the central government or the central parliament will always have more powers, more influence, and more hold over regional governments. When we use the word symmetric federalism, this is something which is rarely or negligibly seen in India. Symmetric federalism effectively means this. When we talk about federalism, you've got center here, you've got state one, state two, state three, state four, and so on and so forth. The idea of symmetric federalism is a fairly simple one. It means that all the states are equally positioned in our country. And that, of course, is not the case because of the fact that the states come from very different characteristics, because of the fact that the states are very differently placed. They have different socio-economic indicators. They have different elements of population, literacy, resources. So symmetric federalism does not particularly work in India. You'll find this as a concept closer to the US, wherein you'll have more powers. In fact, you'll see symmetric federalism more prevalent in countries where the states are a little more powerful, which means being quasi-federal is inversely proportional to being symmetric. Because if you are symmetric, that means the states have been given substantially equal powers. And it could also therefore mean that the central powers would be slightly lesser. But being quasi-federal is directly proportional to being asymmetric. Now, asymmetric federalism would mean that states are not equal to each other, and the center is not treating the states in the same manner. And there are far too many examples of this. For example, every state will have its own number of legislative assembly members. Only a few states are going to have legislative councils. The numbers of these councils and the numbers of these assemblies are also varied, and they're also determined centrally. So, of course, you have quasi-federalism when it comes to asymmetricity. You'll also see, for example, some special arrangements that are made for greater autonomy, for greater governance. For the longest time, we had something called Article 370, which is now not operational, post the abrogation of it. But Article 370 effectively gave the state of J&K a greater degree of autonomy, a greater degree of self-reliance, of self-governance. So India is more suited to what is called an asymmetric form of federalism. So are we quasi-federal? Yes. Are we more asymmetric than we could ever be symmetric? Yes. You'll also hear of provisions such as Article 371A. For example, it relates to Nagaland. It goes up till 371G, which extends up till Mizoram. You will also hear of certain mandates which are in the constitution, which are trying to provide some form of positive discrimination to mitigate interstate inequality. You'll also see fifth schedule, sixth schedule. You'll see certain areas of certain states which have been given heightened autonomy, heightened focus, heightened uh, centricity when it comes to governance, and so on and so forth. But the larger question that I think also becomes important for the prelims exam is, if you have to justify the rationale behind asymmetric federalism, and the rationale is actually fairly clear. One of them is it actually ensures unity and diversity in India. And the fact that you're able to preserve unity and diversity in India, you're able to do so because you're able to preserve vulnerable groups. You're able to give respect to the sections of society through certain special powers. Two, you're also able to satisfy the special needs of these federal units. It's a very simple way to look at it. The challenges, the problems, and the solutions of a Punjab versus a Tamil Nadu versus a Bihar are going to be dramatically and drastically different. So I cannot treat all of them the same way. I cannot give them the same opportunity. It's effectively an application of equal protection of law, but to governance and center state relations. So that's the second reason. Third, it also helps to protect fundamental rights, and it also tends to compensate for the initial inequalities that would exist in our social system. So it is also a good rights protection mechanism if you think about it in that manner. And fourth, it also gives you a certain amount of leeway, a certain amount of space for separate laws to govern separate subsections of a society. For example, religion. It also provides for the opportunities of various kinds of affirmative action, and particularly for the extremely disadvantaged groups. And therefore, it is able to give better representation to minorities of any nature in a democracy. So one could aptly say that asymmetric federalism is something that works in our best interest. Now that we've understood that these are the basic units, we must also understand the formats of it. Now, generally, we've heard of something called cooperative federalism and competitive federalism. What does this mean? Now, a very simple understanding of cooperative federalism is it's where the interaction between these units, these constituent authorities, is based on the principle of cooperation, so that they could collectively use their energy, they could collectively use their resources to maximize public welfare, to do whatever it takes to achieve national goals. And governments in these cooperative federalism ecosystems will actually share a very horizontal relationship and not a vertical one. And common policies are mutually discussed. They're debated. They come to a conclusion. It's not done by dictation. It's not done by any form of force in that manner. And cooperative federalism is therefore a very important tool which will enable greater participation in state governments in the formulation and the implementation of these policies. And our constitution does, in fact, provide for interstate cooperation. For example, The first and foremost of interstate cooperation would be schedule number 7. It gives you the three lists. You're supposed to work in coordination with each other. And you also have something called the concurrent list, where both the center and the states can work together. That, in fact, is a form of cooperative federalism. Apart from this, you would have heard of Article 263, which is, I mean, we don't use it anymore. It's sort of a done and dusted body. But we have something called the Interstate Council. And the Interstate Council has been provided to, in fact, resolve any kind of dispute between the center or the states, or in fact, amongst the states. So, cooperation is not just states working together, but the entire ecosystem actually working together. And apart from this, you also have heard of something called zonal councils. Now, these zonal councils, if memory serves me well, were to be established under the State Reorganization Act of 1956. And they were supposed to be instruments of intergovernmental consultation, intergovernmental cooperation. And whether it's the interstate councils or the zonal councils, they haven't really worked. They haven't really been very successful in terms of getting more and more people and more states to work together. Uh, for a brief period of time, we also had something called the National Development Council. Now, it was supposed to be an apex body for decision making, for deliberations on development matters. It was to also have representation from the center and the states, and therefore we wanted to make states a part of the development process. That's not the case anymore. You would have also heard of something called the Interstate Water Disputes Act and the River Boards Act. Now, the Interstate Water Disputes Act and the River Boards Act also provides a means to adjudicate disputes relating to the use, to the sharing of interstate rivers. And after all, one can also not ignore the 73rd and the 74th Amendment, which introduced rural Panchayati Raj, which introduced urban Panchayati Raj, to strengthen the roots of cooperative federalism. So your question has to be a very simple one. How does Panchayati Raj help you in cooperative federalism? Because the center simply gives you a structure to Panchayati Raj, whereas the states actually give you power to Panchayati Raj. So if both of these things work together in sync, it could be an excellent case for cooperative federalism. And in the most modern times, we would have heard of Niti Aayog, which does both a cooperative as well as a competitive role, and we'll come to that in just a bit. Now, when we speak about competitive federalism, in competitive federalism, there will be competition between the center and the states, and there's going to be competition between the state governments. And this is to gain maximum benefits, to facilitate better administration, and to also enhance developmental activities. And competitive federalism has largely been an idea post the 1990s, because if you're opening free market, you're enhancing competition. And why should competition just be for the private sector? The governments should also effectively look at good competition strategies. So the post 1990 economic reform area, uh, that sort of a time gave ground to the idea of competitive federalism, because what was generally happening was, because of LPG, there was a positive impact that the states wanted to also be competitive. There was also a negative impact because of LPG, leading to greater inequalities between different parts of the country, because free market will only exist on in areas which are sustainable, in areas which can give the free market returns. So post 1990s, you will see that the rich got richer, in a manner of speaking, and the poor got poorer. So therefore, in a free market economy, you will see endowments, funds, investments, um, available economic resources, all have fostered a very, very healthy competition. And this kind of a healthy competition is where every government is effectively trying to get the most benefits to improve social and physical infrastructure. And competitive federalism, unlike cooperative federalism, would effectively be following a bottoms up approach, because you are competing at the very basic, and that's where the change comes from. So you'll see more competition here than you will see between the center and the states. So, for example, investors will generally prefer more developed states for investing their money, and the union government will devolve funds to the states on the basis of how the states have allocated the funds that were given to them previously. So, of course, there is a certain amount of truth to it. And uh, the Niti Aayog, which we were generally referring to, has been a fantastic instrument to foster what is called competitive federalism. How's that the case? It's the case because the Niti Aayog also came up with something called regional councils. And these regional councils, and we'll of course do the structure and all of that in detail in the body's lecture, but through the regional councils that are to be provided for, and generally through the Niti Aayog meetings, you would want the states to do well. You will hear of so many indices that the Niti Aayog creates, and these indices are to effectively rank the states on how well are they placed on certain indicators. For example, you would have heard of something called the Niti Aayog SDG India Index, a fantastic resource for the mains exam. The Niti Aayog SDG India Index effectively ranks the states on how close they are to achieve the SDG goals that India has set out for herself. You would have heard of Healthy India Index. It's essentially how close states are to achieving certain health parameters. You'll see the states compete for foreign direct investment. You'll hear of several para-diplomatic activities happening in states, such as Vibrant Gujarat, which just happened very, very recently. You'll hear of things like restructuring center-state schemes. You'd hear of something called centrally structured schemes or centrally sponsored schemes. Now, central sector schemes are schemes where the center pays the whole of it. Centrally sponsored schemes are those where the expenses of the schemes are shared between the center and the states. And post Niti Aayog intervention, we have something called core of core, we've got something called core, and we've got something called optional. Now, it's a very interesting point. How does restructuring centrally sponsored schemes help you with more competitive federalism or help you with federalism? It's because now the allocation of grants for these schemes should also be based on certain performances. It has to be also based on certain minimal assurances. And the center can condition its transfer of funds, transfer of grants, based on how effective and efficient the state governments have been when it comes to implementing centrally sponsored schemes. You would have heard of things like the aspirational districts program. You would have heard of things like the smart cities mission. All of these are essentially tools of what is called competitive federalism. And that's how we are building the India of today. It's a combination of both cooperative and competitive federalism. That's the general understanding of how federalism in India actually works. And the truth to all of this is that India does need a mix of both competitive and cooperative federalism, or as the Niti Aayog often calls it, competitive cooperative federalism, in a manner of speaking. Now that we've understood this, we must now understand what are the preconditions of federalism. How does federalism become more and more efficient? How does federalism become more and more structured in a country like India? One of the first essentials to federalism is a written constitution, and there have been PYQs from here as well. Unless you don't have a written constitution, you cannot clearly bifurcate powers between the center and the states. And if you cannot bifurcate powers between the center and the states, then there is always going to be some form of conflict, because you have to have two power centers, if you don't clearly bifurcate powers, there is going to be some form of a conflict in some form of another, in some way or another. And that is why a written constitution becomes essential. And a written constitution, therefore, also becomes a very good source of rule of law. It also upholds what is called constitutionalism. If you think about it, if constitutionalism is about uh, controlling the powers of the state, by dividing the powers between the center and the states, you are effectively upholding constitutionalism through federalism. So, federalism's relationship with constitutionalism is very clearly cut out. And if you have absence of arbitrary power and predominance of legal spirit as your two primary pillars out of three of rule of law, unless you have a written constitution which clearly bifurcates the power division, there will often be instances of arbitrary exercise of power. And if you do not give a written constitution, you cannot give a source as to what to do if there is a conflict. And that would therefore further dilute the concept of predominance of legal spirit. And thirdly, when we speak of equality before law, we speak of equal protection of law. And a heightened application of equal protection of law is nothing but the forms of asymmetric federalism, where you're treating some states specially, and the states and the states that are alike should be treated alike, but if you're not alike, you should not be treated the same way, is nothing but an application of the principle of equality before law. So with federalism, you have constitutionalism and rule of law as a direct uh, linkage. But apart from this, and apart from the written constitution, you will very categorically be requiring what is called an independent judiciary. And why is that the case? That is the case because if there is going to be a conflict, if the constitution has to be interpreted, if the nature of federalism has to be understood better, then you would have to have an impartial judiciary. And not just an impartial judiciary, a judiciary which is truly independent in their functioning, in their composition, in their reporting structure, and a secure judiciary, which is what we have. So, an independent judiciary becomes exceedingly a precondition to having an effective federal polity. And thirdly, once you are independent, you would have the powers to review legislative action or executive action. And this legislative action or executive action would also mean interpreting laws or executive actions which govern center and the states. So whether it's interpreting a provision of the constitution, whether it is solving a center state dispute, whether it is filling a gap between the powers that exist between the center and the states, or giving clarity on certain offices such as the role of the governor. You cannot do all of those things if you don't have powers of judicial review. So independent judiciary with judicial review, wherein the courts have a constitutional status. In India, we have constitutional courts, are all fundamentally linked to what is called federalism. So therefore, it's not just federalism. There is constitutionalism, there is rule of law, there's absence of arbitrary power, there is equality before law, equal protection of law, there's predominance of legal spirit, there's a written constitution, there's an independent judiciary, there is judicial review, there is also the fact that your courts are having a constitutional status. All of this will effectively have an impact on what is called federalism. And this is how you're able to make sure that you are building an efficient structure. And as I discussed in lecture number 9, there is a distinct but a very important relationship between separation of powers and federalism. And there is a reason behind it. Because separation of powers is not just separating powers between the legislature, the executive, and the judiciary, but the fact that the legislature can do this and it means the legislature can't do that, And one of the things that the legislature can't do, for example, at the union, is what the legislature at the states can do. So you will have an extension of application to separation of powers. But if in the prelims exam we get a question, which of these are essentials to federalism, you have to choose an option which has at least all of these three that I have mentioned before you. Now that we understand this, we must also understand the federal framework of the country. See, the federal framework of the country could be best understood in four simple points. The first is that we have two levels of government: a general government for the whole country and more regional governments for different parts of the country. Now, what is very interesting about the country of ours is not only do we have central governments, we have state governments also. And we also have governments in union territories, some of which have proper provincial governments like Delhi and Pondicherry, and in the future J&K hopefully. But we also have union territory governments in things like Daman and Diu, in things like Daman and Diu and Dadar Nagar Haveli, which is a combined union territory, like Andaman, like Pondicherry, and so on and so forth. So the one of the essentials again is that you need to have at least two levels of government. Two is we've also categorically distributed some powers or a competence that has to be shared between the center and the states. And you will generally see center-state relations to be understood from a legislative, from an executive, and from a financial standpoint. Now, this financial standpoint is very important for the mains because you'll see fiscal federalism and GST being asked. But in the prelims, this is unnecessarily too complex to be asked. And especially post GST, the ambit of financial relations between the center and the states become extremely limited. So you will have center-state relations, which is dividing relations between the center and the states, which is effectively dividing legislative relations, executive relations, and financial relations in such a way that the center will be stronger than the states. And one of the ways the center could be stronger than the states legislatively would be through, say, emergency provisions, through certain special powers wherein the center can make a law on something which is in the state list. So you'll have those kind of powers also. The Rajya Sabha giving some authorizations for all India states and so on and so forth. I'll discuss this in the next page. So yes, powers are to be distributed, but we have to remember that we are ultimately a center stronger than the states. Country, and this kind of an arrangement is what is generally understood to be the need of the hour. And third, we do have some form of constitutional supremacy when it comes to federalism. That is, that the arrangements that we're talking about, the legislative, the executive, and the financial arrangements, they are effectively given in the constitution. And these arrangements would require very difficult majorities, generally special majority 3 under Article 368, to be amended. And they cannot be amended in an effect because we've also declared federalism to be basic structure due to the SR Bommai case. So the constitution and the fact that we have the basic structure doctrine, which recognizes federalism as one of our core principles, definitely helps. So it basically means that the center or the states cannot unilaterally change the powers that are arranged between the center and the states. And there is also a clear-cut dispute resolution mechanism. In fact, you would have heard of the Supreme Court. We've discussed this in the earlier lectures. The original jurisdiction to entertain center-state disputes is with the Supreme Court. And the Constitution also provides for specialized jurisdiction mechanisms such as the interstate water disputes. So the framework has been done in a very intelligently set up manner, but we've always kept one primary goal in mind, and that is that we have a unitary bias. So let's just understand some few broad basic applications of unitary bias, and then we'll get down to legislative executive relations and so on and so forth. So you'd see unitary bias primarily, and starting with the very first part of the Constitution. We've done this in our earlier lecture. If you remember, we've studied something called union and its territory. The fact that the union parliament has unilateral discretion to reconstruct, to deconstruct the boundaries of the state is in fact a form of unitary bias. And at the most, you have a non-binding consultation to the state legislature, which you can also override if time periods are breached. So the idea is that the center plays a stronger role in reorganizing internal territories as per Article 3 and Article 4. If you look at the division of powers between the center and the states, we've spoken about the union list, the state list, and the concurrent list. You will see that the union list has the most amount of powers. And if at all there is a conflict between the union or the states over something in the concurrent list, then the union will always prevail over the states. Again, a very systemic form of a legislative unitary bias. And under special circumstances, as I was telling you, the Union Parliament can legislate on state subjects under very extraordinary circumstances. For example, based on an authorization by the Rajya Sabha, what you could effectively do is the Rajya Sabha could pass a resolution, and this resolution could be passed by a special majority one. And upon passing this resolution, what you would effectively do is you would empower the parliament to create a law adding a new All India service. Or you can also, by the way, empower the parliament to make a law on something which is generally reserved for the state lists. And what is also very unique is even the state governments can request the parliament to make a law over something in the state list. And this can also be done through a same special majority resolution in case the need might be. Because ultimately, what you are creating is a center stronger than the state's ecosystem. Now, apart from this, given the fact that foreign policy is in the union list, so to implement foreign policy which is in the union list, what you could also do is, for example, India has ratified an international document. This means the document is voluntarily binding on India, and any legal changes that we need to make to implement that international document have to be brought in India. And these legal changes would sometimes be on a subject which is in the state list, but it is in the obligation of the parliament. The parliament can effectively be making a law on something in the state list if you are interpreting or if you're implementing an international treaty and you don't even require a Rajya Sabha authorization, generally because despite the fact that the Rajya Sabha is a representative of the states, and our rule number 2 stands firm. The center is going to be stronger than the states. There is going to be a hollow appeasement, and there's going to be an appeasement, and it's going to be a hollow appeasement. So reference to the state legislatures is a hollow appeasement. The fact that you have a state list is a hollow appeasement because you can still have the concept of an emergency and shut down your entire state government if you need to. The fact that the Rajya Sabha authorization works is again a hollow sense of appeasement. And given the recent instances of cross voting in the recent Rajya Sabha, you see a substantial chunk of Rajya Sabha members in alliance with the national political party at the center. And over and above this, the union government also has very clear-cut dedicated powers of appointing the governors, which is a classic case of appointing of the center stronger than the states. The fact that in part 2, we very clearly say that you can have only and only a single citizenship. You cannot be a citizen of a Maharashtra, Madhya Pradesh, or a Telangana. You necessarily have to be a citizen of India and India only. So governors, citizenship, emergency, any of these things are effectively what are called instruments of a unitary bias. And while all of this happens, we also have some very important institutions of governance, like we have an integrated judiciary. wherein judgments of the Supreme Court are binding on all lower courts. The fact that a collegium appoints Supreme Court and High Court judges. The fact that Supreme Court and High Court judges can only be removed by the Parliament. The fact that we have all India services that you all aspire to. The fact that we have an integrated audit machinery. For example, the CAG, which is a constitutional body, can literally audit, anything which qualifies as Article 12 as far as Part 3 is concerned, as far as state is concerned. And the CAG can therefore audit any institution which is government, whether it's a central institution or a state institution. The fact that you have such an integrated machinery, the fact that you have an election commission of India which conducts elections to the president, to the vice president, to the Lok Sabha, to the Rajya Sabha, to the state legislative assembly, to state legislative councils. These are all, an election commission and CAG are both centrally appointed institutions, the centrally removed institutions. These are all forms of what is called a unitary bias. Now that we understand this, we will then move into understanding the format of division between the regional and the state governments. We'll understand the distribution of legislative power and the executive power, and we'll also understand the applications of emergency. So let's move to unitary, to understanding a broad ecosystem of central and regional governments. So therefore, when we look at a general outline of the central and regional governments in India, there are a few quick pointers that make us understand how federalism is intertwined between central and regional governments. The first and the most important point to my mind is the fact that we have 28 states and about 8 union territories. What is important is none of these states or none of these union territories have any separate constitution of their own. They're governed by a singular constitution called the Constitution of India. And at the same time, there are certain special features, special considerations of the states that I've given you a prior reference to, which is Article 371, 371A till about G, which effectively relates to the notions of asymmetric federalism. I'm going to be very clear about this. The technical details or which state is covered under what sub-article does not have to be done for the prelims exam. So one has to be very careful by not unnecessarily trying to memorize details that are not required. At the very same time, because our federal arrangement is truly unique, not only do we have state governments, we also tend to have something called union territories. Now, union territories originally and ordinarily are centrally administered territories, but we have given two union territories a different kind of a treatment in the legal scheme of India. We've got Article 239 AA for Delhi and 239B for Pondicherry. And both of these articles effectively tell you a larger way of understanding the unique nature of the federalism of India. The fact that Delhi, despite being a union territory, and because of the fact that it houses the central government, also gets a legislature of its own, also owing to the population of Delhi, gives it a unique feature. A similar understanding could be applied to Pondicherry, except for the fact that for Pondicherry, the primary reasons were population and not the fact that the central government was housed in Delhi. Now, the fact that even union territories, not only are the states differently or asymmetrically aligned, the union territories are also asymmetrically aligned, gives you a larger understanding of how deeply asymmetric the Indian federal system is. And not only this, as I was giving you a prior reference, there are some special arrangements that have also been made for scheduled and tribal areas. Now, the basic difference is that while the provisions of the fifth schedule apply to the scheduled areas and the scheduled tribes of any state, the provisions of the sixth schedule only apply to the AMTM states. And this is a prelims question for you right here. These AMTM states are Assam, Meghalaya, Tripura, and Mizoram. And therefore, you have given them a heightened amount of autonomy. In fact, in the next lecture of local self-government, I have done a comparative table comparing provisions of the 73rd, 74th Amendment, the Panchayat Extension Scheduled Act, and the 6th Schedule, because they provide for very, very different mechanisms of existence. So the fact that you have these special areas effectively also tell you how unique India's federal nature is. And there is a clear relationship between the scheduled areas and the federal setup of the country. And finally, from a jurisprudential point of view, the very first article of the Constitution, which is Article 1, Clause 1, effectively tells you that India, that is Bharat, shall be a union of states. Now, what are the interpretations of this? The first interpretation is because they use the word states, India must always have at least more than one state, and that's the primary understanding. And two, whether Article 1, Clause 1 can be deleted or amended will be answered through the basic structure doctrine. And the fact that territorial integrity is an instrument of basic structure, whether Article 1, Clause 1 can be added or removed, has not been clearly identified, largely because of the fact that you do not have such kind of a discussion, and you've not had an opportunity before the court to get into it, and therefore you get down to understanding as to what does the court really have with respect to the basic structure doctrine. Now the courts, while enumerating the ingredients of the basic structure doctrine, have very clearly identified that federalism is a part of the basic structure, and therefore anything that perversely changes the very idea of federalism is not constitutionally sustainable. And this has been defined in the Supreme Court case of S.R. Bomai. Now, does that mean you cannot make any changes in the nature of federalism? Of course, you can, as long as you have kept the idea of federalism intact. You can make the changes that are permissible, and these changes would also be correlative to the kind of extent that has been determined by the legislative powers enshrined in the Constitution. And while federalism is a part of the Constitution, it is an ingredient of the basic structure because of the fact that the parliament can redraw state boundaries, and how unequal are the representation of states in the parliament. They are unequal for two reasons. One, of course, directly in the Rajya Sabha, every state does not have a similar number of seats. It is different from different states, unlike the US. And two, we draw our Lok Sabha constituency state-wise. So the number of seats that are drawn from each state to the Lok Sabha as a method of direct election are also not uniform, and again explains and further identifies the very idea of asymmetric federalism. And as I've explained to you before, the third level of government, which is at the village and the municipal levels, called Panchayati Raj and municipalities respectively, have also had a great impact, because how you manage and execute local self-government will have a great impact on how you understand federalism. There is only so much that the center can do, and there are certain lines that you cannot cross as far as the center is concerned in determining the powers, the extent, and the nature of federalism. And in fact, Article 40 of the Directive Principles guide us specifically for the promotion of Panchayati Raj. It is very unique to note that Article 40 does not give a reference to municipalities. It gives only and only a reference to what is called Panchayati Raj. And apart from this, the whole concept of local self-government exclusively falls under entry 5 of list 2, which is the state list, which is why, while the center can give you a structure to local self-government, it is actually the states that can give you the respective powers, which is why a Sarpanch of UP and a Sarpanch of Kerala will have different powers depending on how much have the states of UP and Kerala devolved powers under the 11th and the 12th schedule. Now, generally, these amendments were hoped to have strengthened the local self-government system in India, and they have in fact given a form and structure, but the core competence of local self-governments would effectively still lie with the states. And therefore, you would have heard of something called devolution indices. This devolution index is prepared by the Ministry of Panchayati Raj, which is again an example of competitive federalism. And depending on your performance in the devolution index, you would be the recipient of a certain amount of funds. In the same way, there has been an issue with how allocations of the Finance Commission of India or the recommendations made by the Finance Commission of India are not very well received by the southern states because they contribute more to the percentage of the GDP, but they get less resources back in terms of the tax dividend that they contribute to. Again, asymmetric federalism and competitive federalism and federalism, which is quasi-natured, all of it coupled in one giant big box. But this is generally the existential framework of the central and the state governments. Once we've understood this, what we've got to now understand are the distribution of powers. And the two powers that we have to understand are effectively legislative powers and executive powers. We don't have to worry about financial powers and the specific distribution of taxes as far as the prelims is concerned. We have not seen a single question from here in the last 10 years or so. But legislative powers we must be very clear about, and with a little bit of an insight into judicial powers as well. And we've anyways covered the judicial structure, so that's going to be a little bit of a 10-minute revision for you. But let's understand this. As far as legislative powers are concerned, categorically mentioned in chapter 11 through articles 119 to about 209 with respect to the center and the states, we must understand very specifically Article 245. Now, why is Article 245 so important? Because Article 245 describes the territorial jurisdiction of the parliament and the state legislatures. This means Article 245 gives you the extent to which the union parliament and the state legislatures will have their laws that are applicable. So the basic understanding is that Article 245 tells you that parliament laws are made pan-India, whereas state laws are made to the territory of the state or any part of the territory of the state. And quickly following Article 245 is Article 246, which is cross-referenced with the 7th schedule, which lays down your union list, your state list, and your concurrent list. So what does Article 246 tell us importantly for the exam? As we discussed before, the items in the union list are more than the 3 items. In case there is a conflict, and this is important, items in the union list will override the items in the state list and the concurrent list, and items in the concurrent list will override items in the state list. This is a very important point to take note of. This is a central supervision of authorities. So, for example, if the union list tells you about agricultural markets, but the state list tells you agriculture, so the union list overrides the state list. In the same way, transfer of property is in the union list, whereas, for example, local laws or local tenancy laws or land is in the state list, but transfer of property is in the union list. So the union can make a model law called the Real Estate Regulation Act. Quite an underlooked and a neglected fact, but there is a certain amount of truth to it. And the most important for us for the exam, because this is not a matter of interpretation, but constitutionally, any residuary subject shall also have precedence over the powers of the state list and the concurrent list. Now, a residuary subject is anything which is not mentioned in the state list or the concurrent list, and it will be assumed to be the prerogative of the parliament through the union list. In fact, the very last item of the union list says anything which is not covered in either of the two lists. And as far as the concurrent list is concerned, the state, if at all, and in the concurrent list, both the center and the states can make a law. If a state law is conflicting with the law of the parliament, then the parliamentary law will prevail over the state law. For example, criminal law is in the concurrent list. So if the state government has made a specialized criminal law on a specialized type of crime on which there is no central law, and tomorrow the central law comes up, then the central law will override the state specific law. And this is important. However, this is very, very important if you read the Article 254 very, very properly. With the prior approval of the president, which is again the center stronger than the states, because the president is bound by the advice of the Council of Ministers. With respect to state list, if the president permits, then the state law can also prevail over the law of the parliament. This is again extremely misunderstood and often overlooked as a point. What is also very interesting to note as an interpretation is that no tax entry whatsoever is included in list number 3. This basically means that taxation is very clearly defined as a central domain or a state domain. You do not have joint taxation powers simply because it would lead to a lot of arbitrariness and it would effectively violate what is called rule of law. And legislative powers that have been assigned to the union will always have primacy over powers that have been attached to the states. So the union list will always have more powers than the state list, as is the case. And generally, what happens is because of certain special considerations, the parliament can override the distribution of legislative powers, for example, due to an emergency. And if that is the case, the parliament can make a law on anything which is in any item in the state list. And not only this, in a state emergency, the parliament can also effectively uh, make the entire state executive or the entire state legislature be suspended or in fact be removed circumstantially. But in a national emergency, basically what you have is a union list and a concurrent list. Because for that particular region or for the country, the parliament can also make a law on something in the state list. The state can also make a law, but so can the parliament. And as I said before, the parliament does not need anybody's permission if you're implementing any treaty agreement or something which has been ratified by India due to an international conference or any ratification whatsoever. This was also asked previously uh, in a previous year question. Now, because presidential emergencies become so important, and this is logically the next order of things, you will have the president of India, if they are satisfied that the government of any state is not working in accordance with the provisions of the constitution, or there's a failure of constitutional machinery, then you will assume all the powers of the state, and the parliament will therefore make laws for the entire state. So a state emergency becomes a far more hyper focused national emergency. And I'll give you a comparative understanding, therefore. And the idea is that under normal circumstances, everybody does their own thing, the union list, the state list, and the concurrent list. But these exceptions have been invoked in a fairly limited number of cases. We've had more than 100 state emergencies since the birth of this country. We've had just about 3 national emergencies up until now. But the larger understanding is this: we've had no financial emergency imposed in India formally up until today, which is March 2020, which is up until Feb and March 2024. And this is generally what is called the basic understanding of distribution of powers. What we need to know for distribution of powers for the prelims is what is the general arrangement and what is the special arrangement. The special arrangement would be when the parliament can make a law over something in the state list. And we've understood it could be either because of a Rajya Sabha authorization, or it could be because of a state request, or it could be because the parliament can directly do so. And we've covered all the scenarios, which are special circumstances where the parliament is overriding something which has already happened at the level of the overriding the mandate of the states. And very quickly, we must also understand the executive and the judicial powers, though they're not very technical. We've always understood when we studied the executive that the executive powers of the union and the states are coextensive with the legislative powers of the union and the states, which means that the executive power of the union would be to the extent on which the union has the powers to make laws. And sometimes the implementation of the laws would require the union to work in close association or take certain calls at the level of the states. So generally, yes, your executive powers are categorically divided, but the executive power of the union will also extend to all those matters, to all those scenarios and circumstances where the parliament has the powers to make laws, and also those where you have decided to make a law giving rise to an international treaty because you've ratified it. So if that ratification is also on something which is in the state list, and now you have to implement that law that you have passed in the parliament, then you will also have the executive powers associated with it. And this becomes a very unique case because if there is an international treaty and you have to make a law to implement that treaty, but that law was in the state list, the parliament can pass that law without any Rajya Sabha authorization. And once you have passed that law, you may also have to implement that law. And therefore, the executive will have the power to implement this law also, even if it is from a subject which is in the state list. And that's what makes the executive powers very unique. However, the executive power of the union does not extend to matters included in list 3 unless it is provided in the constitution or it is provided for in the parliament. This is categorically mentioned under article 73, though this particular part, because it is judicially often questioned, is not important for the prelims exam, but you should know as a general idea. See, the executive powers of the states will extend to matters on which the state legislatures have the power to make laws. And subject is that, of course, to the condition that these are matters which are in the concurrent list and it is subject to the union's power. So for 173, you have a counter of 162. If the center has been given implementation powers or something in the concurrent list, then naturally the states will not have these. Now, there are, of course, certain special cases or exceptions to the larger ecosystem of executive powers. The first is that when you are implementing the executive powers as the state legislature, you have to make sure that even while doing so, even when you're implementing something as the state, you have the executive power to do so. While implementing a state law on which you have executive power to do so, you still cannot violate any parliamentary law because it will also be operational in the country, and the country includes the states. And if there is already a prevailing law and this prevailing law is applicable in that particular state, then you have to make sure that the union has the executive power to give directions to the state if needed. So this effectively makes it very, very unique that there is no clear-cut division on the fact that states' executive powers are only till the state. Here also you will see a little bit of an intersection of center stronger than the states, which means very basically that there is a central law a parliamentary law. Now, that parliamentary law would also have to be enacted, and the state government will also have some laws on their own, and they would be executing some laws. Now, these should not interfere with the larger applicability of a parliamentary law in the country. So that becomes very, very important. Like, for example, atomic energy is a central subject, but land is a state subject. So if you need to require land for atomic energy, the states will have to comply. The executive order will have to comply. So on and so forth. And also, for some nationally important instruments like the military, like the railways, you will have to give some leeway to the states. You will have to make sure that the states are able to comply to central directions. And you have to make sure that if the center says that I want X land because I'm constructing a railway line, the states should facilitate the same. And your corresponding articles for these, though not important for the exam, is of course through here. But generally, this is the idea of executive powers. We've not generally seen questions from executive powers in the prelims in the last 10 years. But given the fact that you generally get conceptual questions, this should be good enough to get you through any of the executive federal question that could come. And lastly, you have something called judicial powers. Now, what is interesting about judicial powers is that the constitution does not divide judicial powers between the union and the states. Though you have a separate section on union judiciary and a separate section on state judiciary, but you don't divide judicial power per se, because of the fact that something as simple as Supreme Court judgments are binding on the entirety of the country, and the fact that the Supreme Court can hear literally any form of appeal. In fact, what we have is a very, very integrated judicial system. And an integrated judicial system is a very unique proposition for federalism in the country. In fact, when your Supreme Court and High Court judges are to be appointed, it is in fact, and they're appointed through a collegium process, and the states play a very limited role through the memorandum of procedure and so on and so forth. But they play a very limited role nonetheless. So, an integrated judiciary becomes a very interesting proposition to federalism. And when we have something called a higher judiciary and a lower judiciary, you will also have different placements of the same. So, for example, uh, the parliament has been authorized to create additional courts for the administration of union laws, the creation of an all India judicial service. These are all extensions of judicial relations between the center and the states. The fact that an all India judicial service, which is to be created for the position of a district judge and in and around it, and this could be done by a parliamentary law, and we've already passed a resolution for it. And generally, lower judiciary is managed by the state government, recruited by the state government. The high court judges are on the interview panel. The governor makes the formal appointment to lower court judges. You still have the parliament. The powers to have all India judicial services is also nothing but center stronger than the states. And except for the appointment of the judges of the Supreme Court and the High Court, which is made by the President of India, and appointment the entire appointment of the administrative staff of the Supreme Court, the budget of the Supreme Court is within the jurisdiction of the union government. The central government pays for the Supreme Court of India, and the state governments pay for the high courts and the costs of the high courts. The only difference being that the pensions of high court judges are charged to the Consolidated Fund of India, because they're not permitted to practice in the same state where they had retired as a high court judge. And therefore, what generally ends up happening is that you have created a very nuanced system of Supreme Court and High Court judges. And very interestingly, through 146 and 229, whether it is the Supreme Court or the High Courts, both of them will decide on laws of the center and the states. We've covered this before, that the High Courts can also determine the constitutionality of a central law, and the Supreme Court can obviously determine the constitutionality of a state law. And this has been a previous question again. And therefore, you could very clearly understand that the judiciary was always envisaged and arranged to have more of a unitary character, and not have a very federal influence, because you didn't want local factors playing a role in the recruitment of the judiciary. This is why the relationship between judiciary and federalism is something which is very argumentative in nature, and that automatically excludes it from the relevance as far as the prelims exam is concerned. Which now finally makes me go to the exception of the federal rule, a massive central power consolidation exercise, which is emergency. Now, what you must understand about emergency again is, though it is important from a polity point of view, it has not been asked in the last 10 years in any form whatsoever. But let's understand what it is. So, the basic rule of law, or the basic provision as far as emergencies are concerned, is this. Today, you can impose an emergency, and this is promulgated by the president exclusively on the written advice of the cabinet. And it is only here that you find the word cabinet mentioned in the constitution. Otherwise, the word cabinet is not mentioned anywhere in the constitution. What is also important is, when you're studying the emergency for the prelims, you don't have to study the inherent procedure of it. What you must understand is the larger layout of it and the larger impact of the emergency as we deem fit. And that's effectively what is the most productive. Now, what you will generally see is that through the emergency, it is the center which takes great influence and control over the affairs of the states. So let's understand this. Our constitution envisages three kinds of emergencies: a national emergency, a state emergency, and a financial emergency. Now, as far as a national emergency is concerned, this has happened very few times, and a national emergency is articulated under Article 352 of the Constitution. Now, what happens with the national emergency is we have to identify the grounds. Now, the grounds have been changed. Today, you only have three grounds: war, external aggression, and armed rebellion. We used to previously have internal disturbances, which was rephrased because of its inherent misuse. So war, external aggression, and armed rebellion are the three primary grounds on the basis of which national emergency can be imposed. Now, national emergency is imposed, could be at a pan-India scale, it could be on a specific state, it could be also within a state. There is absolutely no territorial limitation as far as a national emergency is concerned. And this territorial extent of the national emergency is completely circumstantial, depending on the nature of the war, the nature of external aggression, and the nature of armed rebellion. And this is enough for the prelims exam. Once we understand the grounds and the extent, we also understand the impact. Now, the impact of the national emergency is very simply understood in terms of the impact on the organs of the state. So you've got the parliament, you've got state legislatures, you've got the union executive, you've got the state executive, and you have fundamental rights. So there is absolutely no impact whatsoever on any uh, legislature or executive of the state in terms of their structure, in terms of their existence. Because if you look at the grounds, there is no need to shut down a legislature if the country is undergoing war. What you need to do is make sure that if there's a necessity of certain laws that have to be made, they will be made. What you have to make sure is that some ordinary rights that the citizens would have ordinarily had as fundamental rights, they might have to be put in a brief pause. And the grounds will make you understand the impact. So, what generally happens in a national emergency is the parliament can also make laws on something which is in the state list, and that's all that happens. Otherwise, can the states make the same laws? Yes. But if the parliament has made the law, then the state cannot make the law on the same thing that the parliament has made the law. But does anything happen to union legislatures in any of the emergencies? No, which is why I call it a central consolidation exercise. and nothing happens to state legislatures or, for example, the state executive, as far as a national emergency is concerned. What it simply means is that the parliament can also make laws on something in the state list. It does not mean that only the states can make a law. So the parliament can also, the key word being can also, make laws on the state list. This is the key striking feature of a national emergency. And as far as fundamental rights are concerned, just think about it logically. The country is under a security threat, which means that my primary freedoms of speech and expression, peaceful assembly without arms, forming an association, movement, to reside and to settle, to carry on any profession, occupation, trade, or business, they are fundamentally in conflict with the country being under a security threat. You can't be under a security, you can't be under a grave security threat, and the citizens are freely moving from one corner to the other, which is why you will see that Article 19 is automatically suspended. And through Supreme Court judgments and amendments, it's generally understood you can suspend any fundamental right except Article 20 and 21. 20 are your general principles of criminal justice, and 21 is life and liberty. What is important to understand is the role of Article 32. See, what happens in a national emergency is that if your fundamental right is violated, let us say your Article 14 has been violated, but Article 14 has not been suspended in a national emergency, but 32 is suspended. That means till the time the national emergency is applicable, you cannot go to the Supreme Court claiming a violation of Article 14. What you will have to do is that you'll have to wait for the national emergency to be over so that 32 is again back in action, and then again question the decision of the state which violated Article 14. So 32 can be suspended. It is temporary in nature. It means that you can't come to court at that very moment. You have to wait for the emergency to end because we are under a security threat. That's pretty much it. And as far as the procedure is concerned, not very relevant for the prelims exam, a national emergency technically can be for an infinite amount of time, which means a national emergency can be forever, but it has to be done in intervals of 6 months. So, for example, if it's Jan 2024, you can have your national emergency renewed infinitely every 6 months from Jan 2024. But by the end of Jan, by 1st of Feb, you would have had to approve the national emergency, and this approval needs to be done by both the houses, requiring special majority too, because it has a federal impact, as the parliament can also make laws on something which is in the state list. And that's basically the procedure. If for any reason one of the houses is not there, even one house is approved is enough. The second house can come back. Whenever the second house sits, they will have to approve. If they don't, then the emergency cannot continue. And the reason why you would require a parliamentary approval for any form of an emergency is because of rule number 1, which is nothing but democratic mandate. The key to it all, because ultimately you are transferring or you are allowing legislative powers to also be used by another layer of government. And that's effectively what is national emergency. Now, as far as state emergencies are concerned, the most popular ones, we've understood this partially through the governor as well. It's under Article 356, and it is implemented within a particular state. It is on the entirety of a state. And the grounds for imposing a state emergency, or as it is called, a precedence rule, is the failure of constitutional machinery in a state. Now, the governor has constitutional discretion to submit a report suggesting that a president's rule should be there, or even if there is no report, the president can still promulgate a state emergency. This report is under no circumstances compulsory at all to impose what is called a state emergency. Now, the grounds are enough indicators to make you understand the impact of it. Now, if it's a central consolidation of power, then absolutely nothing will happen to the union parliament and the state legislature. But the failure of constitutional machinery is primarily because the state government has not been able to manage things very well. So you will definitely be suspending the state executive, the state council of ministers. And depending on how grave the failure is, you can temporarily suspend them. You can also dissolve them entirely if you need to. And this is a dissolution of the state legislative assembly. That means the center has the powers to dissolve a state assembly for 356. There have been quite a few political cases here or there, but that's the case. And if the parliament wants, the parliament may make laws for the state if, let's say, the state legislature is suspended and so on and so forth. There's absolutely no compulsion whatsoever. And because the grounds are the failure of constitutional machinery, you cannot further endanger constitution by reducing fundamental rights. So there's absolutely no impact whatsoever on fundamental rights. But this is basic. This is all that we really need to know. And unlike a national emergency, you can have a total duration of 3 years, but this 3 years is done in a certain amount of increments. The increments is, for the first time, you can have a state emergency for 1 year, and then you can have it for another 2 years, but at intervals of 6 months each. You would also require an initial approval. The initial approval has to come from the parliament, but this time you've got 2 months to give an approval, and the approval will only and only require a simple majority, which again shows you that this is going to affect states more, and this is going to take away a lot of state autonomy, and you have given a simpler majority and a longer approval time, thereby proving center stronger than the states. And then you have financial emergency under Article 360, where your basic ground is that there is an issue of financial instability. There is a financial stability threat. There's absolutely no extent that has been discussed, but basically the idea behind a financial emergency is that do whatever it takes to save money. So anything which charged on the CFI could be reduced. Everybody's salaries could be reduced. Any major capital expenditures could be reduced. What you're effectively looking at is a conservative fiscal policy. Now, this does not have any impact on the structure and the function of the branches of government. So nothing happens to the union and the state legislatures and the executive, and it has no correlation with fundamental rights. So nothing happens to fundamental rights. And you never know how long a financial issue might last. So it can be for an infinite amount of time. It requires a one-time approval, and it is done through a simple majority. That's all that you really need to know as far as emergencies and prelims is concerned. On purpose, I've kept a very strong amount of restraint while doing federalism, because the nature, the frequency, and the depth of questions are very conceptual when it comes to federalism in the last 10 years, and we have to keep up with how the exam asks. So this is how lecture number 10 is to be done. Lecture 11 is on local self-government and miscellaneous provisions. We'll quickly cover them immediately after this. See you in lecture number 11, and then we're left with bodies post that. Thank you.